Okay guys, welcome back to another episode of Lawyered Up. I didn't do the Lawyered Up at 6 o'clock like I normally do because this is going to be kind of a quick update type thing. There haven't been a lot of developments in the cases. We're just waiting for stuff. There were a couple of things that I wanted to talk to you guys about. The first one, and if you guys have any questions about a case, you want something to be covered up here, pop them into the chat. I'll take a look at it. None of this stuff is in tribal court, but I do think it's interesting. The first thing I wanted to talk about was, I don't know if you guys have seen in the news, but Governor Kevin Stitt has a brother. His name is Marvin Keith Stitt, and he currently has a lawsuit in the Court of Criminal Appeals, it's an appeal really, about a speeding ticket that he got in Tulsa County. And I wanted to take a look at it just because there's been an amicus brief that's been filed by the United States government in it that kind of really succinctly outlines the whole argument with Tulsa giving people tickets on the reservation. So let's take a look at it first. And the link to this page that we're looking at right here is in the description of this video too, guys. So here you can see Marvin Keith Stitt versus City of Tulsa. Let's scroll down. I'm going to go all the way to the bottom. This is the list of everything that's happened in court. It's pretty long. You can see that they're still getting extensions of time and etc. in here. But what I wanted to take a look at with you guys today was this brief of Amicus Curiae United States of America, right? So this is the DOJ's opinion on this case, what they think ought to happen. Let's take a look at it. Oop. Let me zoom in for you guys here. A little bit more. Well, maybe not that much. So let's go down here. And really, if you guys want to get a copy of this, you can get it just how I just got it. Go to the link in the description. You can click that PDF. You can download it. You can read it at your leisure. I wanted to just go here and look at these main points of the arguments that that the Department of Justice puts forth, because it's good to see this from the United States government. The first one is U.S. Constitution and principles of inherent tribal sovereignty establish that the United States and tribes, not states, possess authority over Indians within Indian country. Seems to be pretty clear cut. 2. Castro Huerta did not overrule or alter principles of federal law under which states lack criminal jurisdiction over Indians in Indian country, absent congressional authorization. And that's kind of what I was pointing out to you guys previously when we were talking about the other case out of Tulsa, is that the argument that was put forward is that Castro Huerta somehow gave them the ability to prosecute these, and it didn't make any sense. And the DOJ here is saying the same thing. Castro Huerta didn't do that. They do mention congressional authorization because they're talking about if Congress passes a law that says Tulsa can do this, then Tulsa could do it. They're a long way from that. 3. McClanahan and the long-standing principles on which it rests, not Bracker, reflect the framework of assessing state criminal jurisdiction over Indian defendants. Number 3 here, they're just talking about the things that have been put forth by the city of Tulsa, to the rationalizations for evaluating, the legal rationalization for evaluating whether they can write tickets to Indians. And they've been using what's called the Bracker test. And this number 3, they're making an argument that McClanahan is the better case here that does it. And number 4 says McClanahan embodies the general rule against state jurisdiction over Indians in Indian country absent congressional authorization. Number 5, the state of Oklahoma lacks jurisdiction over Indian defendants for crimes committed in Indian country. A. Federal law preempts state criminal jurisdiction over Indians for crimes committed in Indian country. A1. Tribes, including the Mvskoke Creek Nation, possess inherent sovereignty to regulate their internal affairs, including to punish Indian offenders on their reservations. A2. 2, Public Law 280 reflects preemption of state jurisdiction over Indians. If you don't know what Public Law 280 is, in some states that have Indian reservations on them, those Indian reservations agreed with the federal government, and they signed a thing where they said the state courts can handle crimes on their reservation that happen on their reservation. It's legislation that happened there. A3, Oklahoma is not a Public Law 280 state. 3, other federal statutes confirm the preemption of state authority. So they're just saying that no matter what, that in Oklahoma, the state doesn't have authority to prosecute the Indians. B, state criminal jurisdiction over Indian defendants is also prohibited because it would infringe on tribal rights and sovereignty. So this is a big one, guys, just because for me, it's really great to see the federal government, the Department of Justice, make this argument in a brief, saying that it's prohibited because it's going to infringe on tribal rights and sovereignty. That's awesome. 6, if the court elects to apply a Bracker balancing analysis, it should not do so without a developed record on the relevant factors. So, and let's go down here. I'm going to go really quick down to the bottom. Let me switch to this really quick to get the conclusion for you guys, because I think that is also interesting. Conclusion. For the foregoing reasons, the state of Oklahoma lacks jurisdiction to prosecute this case. So, and like I said, you guys, if you want to go through and read this entire brief, it's the link to the OSCN list on this case. This page is in the description of this video. You can go there. You can download all of the PDFs here, but this one is the brief of Amicus Curiae of the United States of America, the Department of Justice. So that's going to carry a lot of weight. Okay, moving on to the next thing. You guys out there might have seen, because I've had citizens send me links to this going, what's going on here? People posting on social media, like for instance, they're reposting this from the Mvskoke Creek Indian Freedmen Band. Let me pop that up for you. And they got a post here saying that in a significant move, Congresswoman Maxine Waters and 12 other members of Congress have filed an amicus to request to support the Creek Freedmen descendants, a cause they believe in and are committed to. And then they have this document down here. So it's not technically wrong, but I do want to point some stuff out. So let's go to the Mvskoke Creek Nation's Supreme Court's website. They have this new tab, and I want to give them props for doing this, because this is great and we're able to actually talk about these things. If you guys have any questions, pop them in the chat. Let's go to current docket, and the case that we're talking about here is Mvskoke Creek Nation versus Rhonda K. Grayson et al. And Kennedy is one of the. So let's go in here, and you can see that I think last time we talked about this order denying motion for leave to file an Amicus Curiae brief, which was the group that included Stinjati, Representative Dewey McClain, Jordan Harmon, and Amy Wang. So that got denied, and the reason is they did not. It says here that MCN Title 27, App 2, Rule 7C provides that a person wishing to intervene or file an amicus curiae brief in an appeal shall file a motion to intervene, and this is highlighted, within 15 days of the entry of the initial review decision accepting the appeal. Okay? So what they're saying here in this first denial is, you guys didn't get this in within 15 days, so we have to deny your motion. This most recent thing that I just showed you that's been circulating social media has also been denied. Down here you can see order denying motion for leave to file amicus curiae brief. So, and this has Maxine Waters together with Representatives Joyce Beatty, Yvette Clark, Emmanuel Cleaver, etc., 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 and any other members of the U.S. House of Representatives who may join. Excuse me, I have to cough. I'm a little sick. Sorry about that, guys. I'm still recovering. So it also got denied. So that I just wanted to point that out to everybody. And again, you can look at these filings on the Mvskoke Creek Nation Supreme Court's website, which is great. So while they asked permission to, where am I at here? I think this can go away. While they asked permission to file a brief, that permission was denied because they didn't do it within the 15 days. Okay. Then that case is still being heard. Or it's not, they're still deliberating it because I don't know if they have had oral arguments in the Kennedy case yet. I guess we'll wait and see. Maybe one day that could get live streamed. That would be great if you're listening, Supreme Court justices and or guys who run their website. Live stream oral arguments. Everybody would love it. And then the last thing I wanted to talk about was the Douglas case. There hasn't really been any developments in it, but I don't know if you guys saw our coverage that we published on April 3rd, so I wanted to point it out to you because it has some interesting stuff in it. Let me close some of my tabs. So on MvskokeMedia.com, you can see this story, Okmulgee County Jail official court appearance delayed. There's a picture of this guy right here. Let me bring that up for you. This guy right here is Douglas. Basically what has happened in a nutshell is Gettner Drummond filed a writ of habeas corpus in federal court, and then the Creek Nation District Court put a stay on their proceedings until the federal court thing gets solved. And then the federal court judge extended a deadline for all the parties to submit briefs until April 30th. So everybody's got till April 30th to get their briefs in. So nothing's going to happen at all before April 30th. And then it'll probably be sometime after that before they really start making some motions and we see something happen here. So that's basically the update that I got for you guys today. And if you want to view that story, just go to our website, MvskokeMedia.com. It should be on the front page there. That was published on April 3rd. I just wanted to catch you guys up on some of the stuff that we have. Nothing too earth-shattering or shocking or anything like that. All of the other cases that we are watching, the Friedman case that's at the federal court level, all of those cases, there haven't been any developments. There've just been the extension of deadlines, etc. So there's nothing to report there. If you guys see a case that we aren't talking about on this show or anything like that, you can email me at jmore@mvskokemedia.com, or you can send a message. You can make a comment on one of these lawyered up videos. Say, hey, why aren't you guys covering this? Or check this case out, I've got a huge laundry list of cases that I check every day, and I go down them and I check, has anything happened? Is there anything to report to, guys? And I'm more than happy to throw another name on that list, another case on that list. So with that being said, I want to thank you guys for tuning in, and I don't see any questions or comments, so I'll see you guys next time. Mado Hadum, Chihicha, please.